Well, thank you all for making the time to be here. I very much appreciate that. I am Rob Patterson. I'm an attorney and in this capacity acting as the appeal authority for Woodland Hills. We are here on, I believe, a number of appeals, land use appeals. There are two cases on remand, case 2104000494 from Judge Brady, case 210401118 from Judge Patterson, and then two more recently filed appeals, one from December 9th of 2021 and one from May 2nd, 2022. Are those all the correct cases and matters that we have here?
That sounds correct to me.
I think that's our understanding as well.
Okay, thank you. The purpose of this hearing is I haven't actually reviewed any of the substance of these appeals yet. My goal here is to try to get my hands around what it is exactly I'm supposed to be reviewing and deciding so that we can get these cases heard as expeditiously as possible while making sure everyone has the time to present the arguments they need to on these matters. Just by way of explanation, I'm going to explain what I have received and reviewed, and then I will address the kind of specific cases and see what else remains for them. So what I have so far, we've exchanged some emails that everyone's been copied on. I was provided by Jody an email with some files from the city. It contained a city position paper that was dated January 10th, 2022. I believe that was regarding the December 9th appeal, and there were 5 exhibits attached to that. I also have 2 appeal documents from the Fujas, one dated December 9th, 2021, the other dated May 2nd, 2022. I was also given a link to I believe a Google Drive from the Fujas that has a number of documents. I have not reviewed those. It looks like there's a lot of information there. Potentially not all of it is relevant at this stage of the proceedings. So I didn't want to waste time and resources by reviewing those things if there wasn't relevant. So I have those documents, but I've not reviewed them. I also looked over the dockets from the 2 cases so I could understand the posture that we're coming from. It looks like in the Brady case, there was an order on March 11th, a judgment on March 31st, and a little bit of activity after. Looks like the final activity there was on April 7th of this year. And Patterson, fairly similarly, a decision or order on March 22nd, and then a final minute entry from May 3rd, which I believe that's all that I have reviewed. So I have a few questions about moving forward on this.
I have a quick question. May
Yes.
I interrupt you?
Please.
I have not seen that either judge has accepted the final judgment. Do you see differently on that?
I hadn't looked for that. I am not sure. I saw I think an entry of judgment in I think it was the Brady case on March 31st, but I could be wrong. I was doing a very quick review of the docket.
I don't believe either judgment that has been submitted by city's council has been accepted yet. That is my understanding. I have not received any notice from the court. And we had actually provided arguments against them both.
From the city side, what is your understanding there?
No, it's my understanding we have final judgments in both cases. I mean, I'm not counsel in those cases for the city, but my understanding is we have final judgments in both cases have been entered by the court.
I know that proposed judgments were submitted. I have not received anything saying that they've been accepted.
Yeah, I mean, we can pull those and show you. I mean, obviously, we have the same source as you have, which is the docket of the court, and we can pull those up and discuss those if that would be helpful.
That might be. Why don't you work on that for a second? I want to address the non-court cases for second. Regarding the December 9th appeal, I have the initial appeal document from the Fujas. I'm going to pull it up for me to review. I believe it is a I have a 6-page PDF with that document signed by the Fujas on December 9th, 2021. And then I also have a city position paper dated January 10th with 5 exhibits. And that's all I have in that case. I don't have a reply, well, what in the court case would be called a reply brief from the Fujas or anything else. I also don't believe I have a particular record for that case. So my question is, it seems like I still need a record in order to decide that case from the city, and then potentially a reply brief from the Fujas. What is your understanding? I'll have city respond to that first, if you wouldn't mind.
Yeah, no, we'd be happy to provide the record of the decision that's being appealed. Then you'd have that, and that we would be happy to supply that.
Okay, and then any objection to a reply brief from the Fujas on that matter?
No objection.
Okay, and Ms. Fuja, any issues with that process?
One thing that I would like to say is I don't mind the process, but I would like to start by kind of requesting that there be no ex parte communications between the city and the hearing officer, so that we can appropriately review all materials that have been given to you and make sure that they are fully complete. It's hard for me, even with the titles and things, to ensure completeness within the construct of this meeting without having all of that in front of me and knowing exactly which Google Drive, exactly which materials you have. So it's actually somewhat impossible for me to be certain that the materials are correct.
And I could certainly appreciate that. So what I will do is I will, once we're finished with this conference, I will send around the 2 documents I have for that case so you can see what I have. And then I would ask city to send the record to that and make sure everyone is copied on that by email. And then after you review that, confirm whether there's any other documents that have already been filed. And then my goal would be to set a date for you to then provide assuming we have everything there, a final reply brief where you can respond to the city's position and address the record and everything in that. Would that be?
And that would be specifically for appeal number 3, correct? Yes,
the December 9th appeal. That'd be specifically for that. And barring any major issues that something wasn't in there that should have been, what would be a time frame? I mean, you know what? I'm going to hold off in time frames because we still have to address other things, and there's a lot of documents we may still have to get done here. So we have.
I had hoped to be given an opportunity. I just like to state for the record that we should not bear the financial burden of this meeting. And my reason for believing that is that we have already paid for 3 out of the 4 of these appeals up front, according to the city fee schedule when we filed those appeals. We do not believe that this meeting would be necessary if there were only 1 appeal before the hearing officer. In the alternative, if the city and the hearing officer agree that this would be required, even if there were only the appeal number 4, we would submit that we should only have to pay 1/4 of the time of this meeting and any of your time in determining in determining the scheduling of this 4th hearing. And that we should not have to pay for any of your time in determining your jurisdiction regarding appeals 1 through 3. And so I just want to put that on the record.
I appreciate it being on the record. And
I would also, can I just say one more thing? I would also ask if it's possible that you prepare an affidavit showing your time that you have spent on the appeals, and if there are times when it is only on determining appeals 1 through 3, that be notated, so that then we only pay 1/4 of the time spent on the combined appeals, and we do not pay for your time spent on appeals 1 through 3.
I'll address my billing practice. I'll explain how I've approached that. I'll be sending an invoice to the city, and my goal is to, and you may have actually seen my May one already. I think it's been like an hour or so. But my practice will be to identify which of the 4 appeals I'm addressing in each time spent, and the general subject matter of what I am addressing. Communications, material review, and so I will identify it that way. As to the fee cost itself, I don't believe I'm the one to decide how the fees are to be allocated. That is, the city council determines the fee schedule. As I kind of indicated in my email, my contract is with the city. It is a contract where they've appointed me for this. My contract says I will bill them, and however they decide to bill it is between the city and any potential applicant. With that, I don't know how I can weigh in on. I don't think I can weigh in on which one. I appreciate it being stated on the record, so that's clear that your position is there. So I appreciate that.
I would also like to add,
If we could, if I could just interrupt, make a record. The city has a different position, does not agree with the appellant, and also agrees with the hearing officer that the fees are outside the scope of this hearing and outside the scope of the duties of the hearing officer.
I appreciate that. I thought that might be the case.
So if this is outside the scope of the duties of the hearing officer, then are we subject to fees for this meeting according to the city's understanding?
I'm not prepared to address issues that are outside of the scope of what we're doing today. I think it's fairly clear what responsibilities are, and I'll just leave it at that.
Okay, for the record, I would submit that we do not agree to pay fees that are not required under the fee structure that was in place at the time the appeal was submitted.
The record has been made by both of you. I appreciate that. I'll just restate my position is I don't believe there is a fee challenge before me. No, that's my jurisdiction right now to hear that. So the record has been made. I will allow that to go forward in whatever process you see fit. For now, I will return back to the matters at hand. Regarding the May 2nd appeal, I only have a document so far from the Fujas. It is and again, realize with the previous statement that you have made, not being able to see exactly what I'm looking at here. I have a where is that dated? May 2020, an appeal document, looks to be about 20 pages, dated signed by the Fujas on May 2nd, 2022. I do not have a city opposition or position paper, nor any reply from the Fujas. I also don't particularly have a record for that proceeding either. So similar with the December 9th appeal, I would think it would be good to have the city provide the record to both sides and then set up a time for the city to submit a brief and then allow the Fujas a final word on that in writing would be my recommended approach. Now with this, I want to address the substance of the matters. I have not reviewed the matters actually as to substance yet. I'm trying to get my hands around the procedural posture of all these matters. Looks like the December 9th appeal regards a temporary certificate of occupancy or extension thereof. And the May 2nd appeal concerns a site plan. Those appear to be separate, well, related to the same property, obviously. They appear to be separate issues related to that property. Is that understanding correct?
Yes, that's my understanding as well. And the owner of the property, Jennifer Adams, is participating in this hearing. One of the owners, I should say.
I'm sorry, I cannot understand you right now. For some reason, I am not getting, not able to hear anyone at this point in time.
Has connection improved?
I can't hear you.
Attempt to disconnect and reconnect, and we will wait for you to come back if you can understand me. I can't send a chat message to everyone.
Hold on one second. Okay, all of a sudden, everything started cutting in and out. I will disconnect and reconnect.
Rob, I wish to go on the record that I have contacted everyone else and their connection is fine.
Okay.
Now I can hear you.
Okay, good. Fantastic. So we were just talking about the May 2nd appeal. And let's see. I believe, Craig, you had just raised the fact that the landowner is also on the call. I'm not sure if there's anything else that you missed. I think I was just stating that I haven't also received a record nor exchange of briefing except for the initial appeal document from the Fujas regarding that May 2nd appeal. And that those two appeals regard different matters, same property, but two different issues regarding that. And the city indicated that was their understanding. Ms. Fuja, is that your understanding as well?
Each appeal is made in regard to a different land use decision. They are each separate and distinct.
So it sounds like, to me at least, those cases would not be good ones to consolidate. We should have separate hearings on that, separate briefing, relate to the same property, but ultimately are separate decisions.
Correct.
My suggestion would be, I have no problem separately briefing it, but I think we're going to cover a lot of the same ground in every hearing because it is involving the same property. And these are just steps in the approval process for that property that it would save everybody time and money if we just had one hearing where these issues could all be addressed as you get to court.
I disagree because I believe that the appeals were submitted at different times and that there were different ordinances in place. And this brings me to one of the questions that we believe needs to be answered prior to any of these appeal hearings being held, which is there have been many changes to our city laws over the course of between the time that the first appeal was submitted in 2020 and currently. And between those submissions, the laws changed, not just once, but multiple times. Therefore, we believe it is critical for both the hearing officer and the appellants to know which sets of ordinances the city asserts as applicable to each of the appeals. Further, Mr. Smith has made arguments to the Utah Bar and Office of Professional Conduct regarding the ex post facto application of land use ordinances in this particular case. He stated in his February 14th, 2022 letter, quote, when zoning requirements are amended, whichever version pre or post amendment is least restrictive will apply. An existing structure that complies with the new zoning, in this case 35 feet measured from finished grade, is a complying structure, subject only to the new standards in the amendment, close quote. Due to these assertions regarding the ex post facto application of land use ordinances, it's important that the city identify in advance of each hearing and in relation to each appeal, which land use ordinances they believe apply to each appeal submitted, so that all parties and the appeal authority may appropriately prepare for each of the hearings.
I'll ask you to respond to that just a second. I just want to clarify one matter. Are you asserting that the law changed between your December 9th and May 2nd appeal?
There were changes to the laws, especially dictating the appeal authority, who it is, and what can be appealed.
Aside from the appeal authority law changes, were there changes to the substantive laws or zoning regulations that govern this property and the uses it was being put to?
There were changes. There were substantive changes between those.
I
Also,
just want to understand that.
Yeah, we disagree with that. We do not believe any substantive changes were made.
there were changes to whose decisions could be appealed. I believe that to be a substantive change.
Okay, so appreciate that position. I think what I need to do, and I guess going back to the earlier question I have, well, we can handle that, I think, somewhat in briefing, and I want you to make, obviously, any arguments you believe is relevant or are relevant to the issues. Is there an issue if we consolidate these in terms of having one hearing date, even if briefing dates are separate?
I have issue with consolidating them, and I will explain why. It is difficult on the same day to keep track of exactly which laws apply to that particular thing. And I think it will be more difficult for everyone to keep straight which set of ordinances apply, unless the city asserts that the only ordinances that apply are those that existed in place as of July 5th, 2019, when the building permit was issued.
And I don't think either party is going to be in a position to make a final concession on any substantive matter during this conference. And I don't want to put any party into that position.
So without that, it becomes difficult because there were so many changes between each one to consolidate them and have it be fairly heard.
I think that's a fairly incorrect characterization of what's happened. I'm sure that Ms. Fuja would disagree with me on that, and I don't see this as difficult for the hearing officer, who's the person who needs to understand these things and make the decisions to understand. I'm sure the hearing officer has argued much more complex issues to a court and others on the same day in the same hearing.
Let me address another matter, as I'm going to ponder that just for a minute here. But regarding the third party here, the actual owner of the property, Ms. Adams, I believe you are representing them. City, what is your, or Ms. Adams, either of you, what is your view of how you would like to participate, Ms. Adams? Or is this a separate briefing and or just participation in terms of being present at the meetings? How do you see that proceeding?
We would like to be involved in the attempt to evict us from our home, yes. All the meetings, that's what we
you like time to submit documents to me for me to review?
Not at this time. We trust the city lawyer to handle it, but yes, if you have any questions, please contact us and we can explain our position. And unless you have questions, you have, specific, at this time, we're just going to participate.
Okay, I appreciate that. I won't be able to necessarily to, address questions to clarify matters, but I will certainly afford you the opportunity to be present at these meetings. And I think with the city, I'll let you coordinate if there's anything you'd like to say to work with the city in conjunction. It sounds like you are on the, at least for certain issues, have a shared position regarding these matters. I want to make sure if you were seeking to file a brief or other matter that you had that opportunity.
Not at this time.
Thank you. So those are the two appeals, and I
would like to also say that we hold that if the city has the Adams presenting testimony or information, either separately or either by themselves or through their counsel, that such time be taken from the time allotted to the city, since they share a common position.
And I will say that I think that was along the lines of what I was indicating, that, allow them to coordinate together and how they want to present things. I do want to make sure everyone is given a chance to present. It does raise another issue that I addressed briefly in my emails. My understanding is that all of these appeals are what I termed on the record. That's a kind of a term of art for land use matters, where there is not additional testimony or materials or evidence submitted outside of what was initially submitted to whatever the appropriate land authority was, and that the appeals are decided based on whatever law is applicable, and then that record. There are not additional matters outside of the record submitted to me for review. My understanding is that all four of these cases are that way, based on the city's ordinance, both recently and before. It talked about record decisions. And
my understanding is that we can submit evidence that is beyond that expert evidence to corroborate our position. Would that be correct?
My understanding is that would not be correct, that we are talking solely about what was, and I'll give a little bit of my understanding of how the law works here. With land use appeals, my decision is not based on whether a particular decision by a city or whoever the city appoints to be their land use authority was necessarily a good idea or not. My review is simply whether the decision was what they call in the legal world arbitrary and capricious, meaning supported by substantial evidence, or illegal, meaning it contradicted some law in effect at the time of the decision. Because of that, I only review what the information was that was presented to the land use authority. The only way I can determine whether something is supported by substantial evidence is looking at what information did they have, and what was that substantial enough to justify the decision.
Okay, my next question would be, would that include then, would the city's record include all expert opinions that had been submitted to the city at that time by experts outside of the city regarding that?
And maybe I'll ask for clarification on, and maybe this is I assume this might be the previous two cases. Is this what we're talking about here?
All cases.
Or all four cases?
All four cases. There have been expert engineering reports submitted that apply to all four cases.
Yes, I mean, those are pretty standard matters that would be part of the city's record of proceedings.
I understand that. However, the city has not included those in their record submission for prior appeal records. Those have been excluded. They have only included the city's own records.
So
Not
again,
the ones submitted to the city.
I have to disagree. And I also think we need to make clear what was submitted to the land use authority is the record, not just what's been submitted to the city over the course of the past 2 years on many different matters.
That would reflect my understanding of the law is whatever the relevant land use authority was, whether that's a building official, a planning commission, a city council, whoever the entity or person that made the final decision, it's the record that was before them at the time they made the decision. And I haven't seen the record, and as we've discussed, I've asked for the record to be presented so we can review that. Let me, before I make sweeping statements about the other two cases, I would like a little bit more clarification on those two remand cases. Mr. Smith, do you have clarification?
Yeah, I have the documents now in front of me, and let me just run through those. These are just court documents. These are not my documents. We have the judgment that was entered on March 11th. My understanding that was a final judgment by the court, not some preliminary judgment or something like that. Then there was a request.
Say what case that is.
Oh, I'm sorry, this is the Brady case. This is Judge
Right.
Brady.
What is that titled?
Tenant Fuja and Megan Fuja versus City of Woodland Hills is the title of the case. The case number is 210-400-494.
Yes, what is the title?
Well-
Is it ruling or is it judgment?
No, it says judgment. I'll hold it up so you can see it. It says judgment right there.
Okay, go down. Let me see the other portion of it. I believe,
There is no other portion. It's only a one-page document. It ends on the second page. That's the second page. And the third page is the mailing certificate. That was, so it's a one-page judgment that was entered and the case was dismissed.
and it was filed what
Well,
day?
let me finish. Let me finish. So then there was a request for alter or amend the judgment that was submitted by the Fujas. And there was a ruling on that request. And it just says, after reviewing the petitioner's reply motion and request for ruling, the court is still convinced that the petitioner's motion alderman should be denied. The court's ruling is sufficiently clear to indicate its ruling on each of the issues raised by the petitioners. The order signed by the court identifies the issue to be remanded. All other claims are dismissed either by application of law or by the petitioner's motion to amend and withdraw their claim. There remains no further consideration for this court. And I'll hold this one up.
The
and
only
then-
document I have,
Not only that, there was, what's that?
I
And
did not
following-
receive any document entitled judgment. I only received this document.
I have no knowledge of what was sent by the court to anybody. I wasn't in the case. These cases were pulled directly from the court's docket. And then there was a subsequent request to alter amend. And the court denied that, saying, and this is dated March 31st, the plaintiff's motion to alter amend is denied. The court's ruling is sufficient and clear to indicate its ruling on each of the issues raised by the plaintiffs. In my understanding, that's a final, we have a final judgment in that case. And there's nothing more the court can or could do, has no jurisdiction to hear any further whatever. I guess there's always post-trial motions that could be brought, but again, we have a final judgment. And then going to the other case, a Patterson case, on May. No, that one's not the one that's signed, but let's see which one's the one that's signed.
This one right here.
Okay. There was a ruling in order to respondent's motion to dismiss filed on March 22nd, 2022. And was there anything after that, Ethan, or is that the last one?
That was the last one. In the email, they noted that they had already ruled on it.
And when there was a final order submitted by the city's council, but the court indicated that it had made its final ruling. All I know is what's in the documents.
So, and will you be representing the city, Mr. Smith, on the remands on those matters?
The remand to this body, yes, but not
Yes,
in
this body.
Yeah.
Okay. And it sounds like you might, Ms. Fuja, have some disputes over what the court has or has not done. Ultimately, I'm in no position to kind of weigh in on that.
Correct. Our understanding is there has been no final judgment on either, especially as both remand back, and they have not fully decided all issues because of the remands.
But with that, I mean, it sounds like there has been remands, which means there's been some kind of order and the court has kicked some issues down to the city, to me, and to decide. So it sounds like it's at least final enough for me to hear whatever issues are remanded. So maybe I'll just leave that where it is. What are the issues in those two cases? I haven't reviewed any of the substance, and I didn't want to delve through a docket to try to figure out what I should be deciding here. So what are the issues? And maybe I'll first address the earlier filed one, case ending 494 from Judge Brady. What is the issue that remains to be heard on remand there?
Would you like me to address that?
Sure, and then I'll let Mr. Smith address it as well.
So there are remanded issues which were not heard by the appeal authority in the original appeal hearing. The appeal authority actually refused to hear the specific issues that have been remanded by Judge Brady and did not hold any public hearing for those issues. Therefore, the record for these issues must be created by the appropriate submission of documents and evidence and in the hearing of the appeal itself on the record. Submission of evidence and arguments has not yet happened regarding these issues because the appeal authority actually restricted what we could submit as far as evidence and documents to only things that they had determined they were willing to hear. And the issues on remand were not issues that they agreed to hear. And what Judge Brady actually remanded was, let me get back to this. I have it specifically here. He remanded hold on, let me grab the appropriate one. He remanded the issue of whether the Adams's property was used in violation of the city's land use ordinances, including claims of building height calculations when the occupancy permit was issued, including whether such a violation requires the withholding of a temporary occupancy permit.
So, okay, Mr. Smith, do you have anything you'd like to
Which
add to that?
document- I'd like to know which document Ms. Fuja is reading from.
I am reading from the ruling on respondent's motion to dismiss issued by Judge Brady on March 11th, 2022.
Okay, and can you be so
It's on
kind?
the second page under the issue of compliance with height calculations of the Adams's residence when the temporary occupancy permit was issued as improperly before this court and is remanded.
And that's why we're trying to hear it. I mean, I guess I'm lost here as to.
I'm just trying to understand what the issue is that I'm supposed to be deciding on that remand. So it sounds like that's a building height issue regarding,
It's not just building height, it includes building height, but it is whether the issuance of a temporary certificate of occupancy for a building, including building height violations possibly, and building height calculations that were on the record by that point in time, were properly done, and whether it meets the code or not under the zoning ordinances, whether they can give a certificate of occupancy or not.
And that's been remanded to be heard by by this body, and that's what we're here trying to set the schedule to do.
And in the concluding remarks, it says, because the issue of whether the issuance of a temporary certificate of occupancy was not decided by the Board of Adjustment, the court remands to the appropriate appeal authority the issue of whether the issuance of a temporary certificate of occupancy was appropriate.
That's
Okay.
correct. And again, but that doesn't change the fact that the record is the record that was made below the, not by the Board of Adjustment, but was made by the body that was then appealed to the Board of Adjustment. So it doesn't change. I don't see, I'm not understanding what this supposedly changes. It just, these are the issues the court remanded, and that's the issues that I believe should be heard.
it seems to me like we're on the same, with the same kind of process with the other ones, is I need the city to give me the record. It's all materials submitted to either the building official or whatever body made that decision for the temporary occupancy certificate or permit. And then.
And we need to see that record as well to ensure that it is complete.
Well, yeah, of course. I mean, there's kind of a, we've never hidden the ball here. I would expect, we will send it to everybody. If somebody has an objection about the record, they can make that objection. Of course. I mean, that's what,
Briefing on that, I assume this has already been, was this already argued before the, not the court, I assume there was an appeal statement filed by the Fujas regarding an appeal. Was there a submission by the city on that matter?
Yes.
Yes.
It
So it
was
sounds
briefed.
like it was just not decided.
Well,
That's my
that's not exactly the case. It was decided that they refused to hear that. And in fact, I have a January 15, 2021 letter from the chairman of the appeal authority that stated, please limit all your evidence and exhibits to those appeals dealing with zoning ordinance chapter 121.10C and chapter 121.040. And we were prevented from presenting any arguments, evidence, or exhibits regarding any other of our appeals.
I don't know what the other appeals were, but the building, for example, when you issue a certificate of occupancy, that there are two parts to that. One part is a zoning part. Another part is a building code part. And I think the Board of Adjustment was saying, you need to take, which the Fujas did, and have it pending, and did make that appeal. They go to separate bodies. The Board of Adjustment is not qualified to make a decision about building codes. And so I think the issue that was before, as identified by the court, is now before this body, and that's what we'll hear. That's what we'll present on.
That sounds good to me. That sounds like right, but do we need briefing from anyone else? It sounds like we probably should have already had the briefing done. I don't want to retread ground or.
We were not given the opportunity to brief or reply to a brief. You know, the city just said this can't be heard. So there was no ability to reply to it because the city refused to hear it.
I disagree with that characterization, and we'll submit the briefs. I mean, they'll be part of the record. They are part of the record.
Okay. And the other case, is that also a challenge to a occupancy certificate, temporary or otherwise?
It's a challenge to the extension of an occupancy, of a temporary occupancy certificate.
And issue on remand, I assume, is a similar thing where a matter was not decided by the previous
It
appeal
wasn't
authority?
even, they had no appeal, no public meeting. They actually decided without holding any open or public meeting, without any full briefing or any of that.
So they didn't decide it, or they just didn't follow
No,
process.
they decided it. They did not follow proper procedure to so do.
Again, on that matter, it sounds like the briefing should have been already submitted, just the
Yes.
previous entity that was in my position didn't decide it properly for whatever reason, as the district court decided.
That'd be correct. It was briefed, and now it's been remanded for a decision by this body.
I disagree that it was fully briefed. I don't believe we were ever given an opportunity to respond. Without seeing the record, I cannot be certain, but that's my belief.
And these, sounds like both of those remanded cases relate to the same issue, a temporary occupancy certificate, and then an extension of that same certificate. A little bit different posture, but the same underlying issue, but at different times of that permit. Is that correct?
That's correct, and that's why we believe that we should hear these appeals together. It makes no sense to parse these.
We do not believe these appeals should be heard together, in part because the city actually joined us. The court offered to combine our appeals before, actually they did consolidate our appeals for a period of time. We opposed that, and the city's legal counsel actually agreed with us and submitted with us opposition to consolidating those two appeals before the court. So we believe it will introduce confusion if they are now consolidated, especially where they're both on remand and could go back to those same judges upon further appeal.
So I'm not necessarily bound to what the district court did. I can kind of handle these proceedings, but that is good information. The other question I have, the more recently filed cases, the May and the December appeals, relate to certain violations of zoning that the Fujas contend took place in certain approvals. Do those stem out of the same approval process as the temporary certificate of occupancy?
No, those stem from new amended plans that had been submitted.
City's
So-
position on that?
Yeah, this December 9th was out of this, is the same. It's a certificate of occupancy. The May appeal was the amended site plan. So yeah, there's a lot of overlap here.
There is a significant amount of overlap, it appears to me. I mean, it seems like we have 3 cases on an occupancy certificate or extension thereof or a renewal thereof in some form. And based on certain violations of zoning code and also a zoning code claim.
I have a question though. They were all separate land use decisions. Hearing them together as one, they were made based upon different sets of evidence available at different times. I believe they should be separately heard. We've also paid separately for each of them.
And again, the fee issue, I can't really address. When I talk about consolidate, I'm not saying I'm going to issue one decision on all 4. What I'm talking about is having one hearing where we can go sequentially. And I think it would be beneficial to me where I hear the history from beginning and we say, okay, here's where it went up to here. A decision is issued, that appeal is done. Subsequent to that, because we are deciding these on a record. So I can only hear evidence up to a certain point on each appeal. Then we go from there, it sounds like to the next one. If we go from there, it sounds like to the next one, to the next one. We have 4 subsequent appeals related to the same property. I want briefing on all of them, but I'm inclined to say we could hear these all in one. I mean, it might be a fairly lengthy hearing, but
I was just going to ask, how much time are you planning to give us for that hearing? Is it going to be all day?
a typical hearing doesn't, I would assume, would be matters. And maybe it's, I will wait to issue a final decision. I mean, I'm going to issue a kind of a minute entry, or a court would call a minute entry on this after we're here, but
We don't believe it'll take anywhere near a day. I mean, this body is an appellate body. The Utah Supreme Court gives people 30 minutes to argue a case. The United States Supreme Court gives people 90 minutes to argue a case. And
But
believe
those
me,
are-
their cases are many times much more complicated than the situation. And that's how they handle it. We'll defer to the hearing officer on how you want to handle it, but I don't, you can schedule whatever time you think is appropriate, obviously, but we don't think we're going to be taking a full day to present our position.
I agree that the appellate court and the Supreme Court both do that, but those are things that have already been fully heard in a trial. This has not been.
Well, I disagree. It has been heard. It was heard by the Land Use Authority, and we are on an appeal from the Land Use Authority.
But we were not given any opportunity to present information to the Land Use Authority prior to their decision-making.
You were given the opportunity that that was appropriate for whatever proceeding it was.
and
No.
I would like to cut off the discussion here. This is going back and forth on matters. Maybe I'll leave to briefing and argument later. Here's what I'm going to say. I would like, it sounds like we have some briefing in the remanded cases. We have a bit of briefing in the 2 appeals, but not complete briefing there. I don't have records from all 4 cases yet, but the city is willing to put that together. We have discussed the participation of the Adamses, and it sounds like they're not going to be filing any additional briefing. If anything comes up, please let me know. Discuss briefing by the city and the Fujas. I'm going to reserve.
Question. In
Yes.
all of this, we have not been told what it is the Fujas are actually wanting as an outcome. I'm requesting that they state what it is they want as an outcome and go from there. They have not, they've just walked around it and presented the same information over and over for the same things. And as the owner builder, I'd like to have an actual stated outcome. Okay?
I can certainly appreciate that. That would make a lot of sense, and it would be helpful for, I think, all of us Again, I haven't reviewed the briefing. That may be there, may not be.
No.
What I'm going to say is I'm going to issue an order regarding consolidation or not of these cases, as well as
I believe before you do that, I have an argument that needs to be presented that is critical to what you are going to be discussing right now. And
Okay.
I need an opportunity to present it. We do not believe that you as the hearing officer have been given legal authority to hear appeals 1 through 3. It's important to understand that when appeal number 1 was submitted, the appeal authority for the city was named the Board of Adjustment. When appeal number 2 was submitted, the Board of Adjustment had since been renamed the Appeal Authority. Ordinance 2022-06 was passed in February of this year. It established the hearing officer as the city's appeal authority. It also, though, limited the jurisdiction of the hearing officer beyond the limits that had previously been established for the Board of Adjustment or the Appeal Authority. It specifically excluded the building inspector from the list of land use authorities whose land use decisions could be appealed to the hearing officer. In May of 2022, Ordinance 2022-16 further emphasized this exclusion by adding the definition of a hearing officer, which specifically prohibits the hearing officer from hearing any decisions of the building official. And that ordinance also replaced the words building inspector in almost every instance with the word building official, including those sections of the code involving issuance of a certificate of occupancy. We do not believe that this ordinance is compliant with LUDMA. Judge Patterson specifically remanded appeal number 2 back to, quote, the appeal authority, not to an appropriate appeal authority. At the time of the filing of this appeal, the city's appeal authority was actually named the, quote, appeal authority with capital A's in both situations. And the appeal authority was specifically listed as one of the respondents in the case. However, by the time the ruling was made in March 2022, the hearing officer had been established with new jurisdictional limitations as the city appeal authority. Judge Patterson was made aware of this by the city's legal counsel in their notice of supplemental authority submitted on March 17th, 2022. Yet he still designated that it was remanded to, quote, the appeal authority capitalized, the same entity listed in the listing of respondents. This is a distinct difference from Judge Brady's use of, quote, the appropriate appeal authority, lowercase, with the words appeal authority not capitalized. Therefore, it is clear that Judge Patterson intended to remand this matter to, quote, the appeal authority that originally refused to hear the matter. If Judge Patterson, who had been fully briefed by the petitioners in response to the notice of supplemental authority on the changes instituted through the adoption of Ordinance 2022-06, specifically named, quote, the appeal authority as the proper body to hear the remanded appeal, then it stands to reason that the appropriate appeal authority to hear appeal number 1, which was submitted prior to appeal number 2, would also be, quote, the appeal authority as named with capital A's. On February 22nd, 2022, we asked the City Council to not pass the proposed changes removing the building inspector from the list of appealable land use authorities, and explained that we felt that this would be contrary to the requirements of LUDMA and would lead to issues with appeals that could be remanded back to the appeal authority in the future. The City Council did not heed our warnings. We had specifically told them you should just change to a hearing officer, but not change what could be appealed. They did not listen, they changed both. It is unclear to us how the hearing officer has ever been granted jurisdiction under Ordinance 2022-06 to hear appeals of land use decisions made by the building inspector, who has now been renamed the building official with the adoption of Ordinance 2022-16. Further, Ordinance 2022-16 specifically prohibits the hearing officer from hearing appeals of decisions of the building official under Title 10, which ordinance we believe to be contrary to LUDMA. We feel that this will make any decision of the hearing officer regarding such appeals illegal, being contrary to law. This will immediately open any decisions of the hearing officer made relative to appeals 1 through 3 to appeal before they are even heard. Mr. Patterson, we ask, if you do not agree, for you to please explain your reasoning and please explain on the record how you have been statutorily granted jurisdiction over the appeals of the decisions of the building inspector, now renamed the building official for the purposes of Title 10.
Want me to weigh in on this, Mr. Patterson?
Sure, please do.
I think there's a fair amount of confusion, and hopefully I can clarify this fairly simply. Anything that was heard by the building inspector that was a land use decision has been remanded back to the appeal authority. The city no longer has a board of adjustment. One of the reasons the city doesn't have a board of adjustment is when you combine the requests for recusals that were given to have various members of the board of adjustment recuse themselves, and the resignations of these citizens who no longer wanted to be involved in the board of adjustment process, we didn't have a quorum. But that we have done nothing to foreclose anything that was appealed. There was a land use decision by the building inspector. Now, that's one of the reasons we changed the name from building inspector, building official. So again, as I think, as you know, typically procedural things relate back, but substantive changes don't. So I don't know. I'm sorry. I'm sorry, Mr. and Mrs. Fuja are confused, but I don't think it's confusing at all. And I think you are the appeal authority, because there is no other appeal authority, and you can hear all of the appeals.
I would like to say we do
Simple
not have a problem with you hearing the appeals, but we want to be certain that there is a record explaining how you have been statutorily granted jurisdiction.
I don't think that's appropriate. I don't think that's appropriate. I don't think the hearing officer has to justify their appointment. If they want to raise that on a later appeal to the district court, they're free to, but I think it's a waste of everybody's time and money that you have to somehow, because of, have to justify your appointment. That's outside the scope of this hearing. You've been appointed, we're here. If they don't want to, if the Fujas determine that you're improper person, they don't have to participate. They're not required to participate. And if they don't want to participate because they don't think your appointment is legitimate, that's their right. But that doesn't mean you have to. I don't go into a court and say, Judge, I don't think you were appointed properly. I don't think the Senate confirmed your appointment. I want you to show me where the Senate met and confirmed your appointment. Or I want to see the letter from the governor that appointed you. And maybe he wasn't the governor then. I mean, that's the kind of stuff we're talking about now.
Let me ask a couple of please, I'd like to ask a couple of questions of Mr. Smith. Does the city have any objection to me hearing the issues on remand or any of the issues raised in the two appeals?
No, we think you're the appropriate person to hear this.
And then relatedly, and this is a little bit contrary to what you just said, it almost sounds like it's almost a subject matter jurisdiction question for me, which if this was a court, I guess they could raise at any time. What's your view on that?
I guess they can raise it and you can hear it, but a court and an ordinary administrative body determines their own jurisdiction.
Okay. Anything else you want to add, Ms. Fuja?
I just want to say that I believe it is important in order to set forth, it says that the hearing officer shall determine if an appeal is timely within the jurisdiction of the appeal authority and the standing of those seeking to participate. I believe that you must determine whether you have jurisdictional authority to hear this. That is one of your requirements under the law, under the procedures of 10.6.3.1a.
Thank you. Appreciate that.
1a.
Yes, I think I know the city code you're referencing. Appreciate that. Okay. Any other matters to get on the record that we want prior to me talking about next steps?
I do have one further matter. We request the opportunity to tailor our appeals for both of the remanded appeals in compliance with the instructions given by Judge Patterson and in order to ease the review burden placed upon the appeal authority.
I appreciate that. We'll get to the next steps that I was about to talk about. I'm going to issue a decision on some of these matters, kind of along the lines of a scheduling order and consolidation or not order. First, however, before I do that, I'd like the city to prepare the records for all 4 cases, submit that all to all the parties. So that way I can see what has and hasn't been briefed, what the record is and potentially is not. That will also allow the Fujas to see what the city considers to be the record and to raise any objections thereto in their briefing. After I receive those records, I will issue a decision. I'll send out an email with an order that explains what I'd be looking for in terms of hearings and a potential briefing schedule for any remaining. I believe there will be at least some additional briefing regarding the recently filed appeals, the December and May appeals. And I will also address whether any additional briefing will be necessary for the remanded cases.
Can I also add something?
Please do.
The temporary permit has been extended multiple times due to the Fuja's interference and action, so just be aware of that. We've not been allowed to finish the things they're complaining about due to their actions.
I appreciate that. I'm trying to hear these things as quickly as possible. I think everyone would like to have these matters done as soon as possible. Ms. Fuja?
May I also ask that if we are not, hold on one second, I'm just trying to get to the right page. That if we are required to consolidate appeals, that the record be very clear as to which laws apply to which appeals. We need to know, and it needs to be on the record, the city's contention of which laws apply to which appeals prior to the appeal hearing.
Okay, I'm just making some notes for my memory on what I'm going to address here. Any further concerns from the city side?
No further concerns.
Appreciate that. When do you expect that we might be able to get, maybe this is, you need some time to coordinate with Jody and others at the city on getting those records submitted and circulated out?
Yeah, I think everything other than if there was a meeting, minutes of the meeting and or a transcript of the meeting, the relevant portion of the meeting, I think everything would be fairly quickly. It might, I probably do need to talk to Jody about trying to expedite that as well. We want to move this thing along, and we're going to try to move this thing, get you the record, out the record to everybody as quickly as we can. But I think it's going to take us a few weeks.
Okay.
Rob, we may need access to some of the numerous Google Drives that Ms. Fuja has done in the past for some of these appeals.
Then I would ask Ms. Fuja if you could circulate whatever documents you believe you have that are relevant to the record to the city folk, and then allow them to prepare the record and then circulate that to me. I will make an order once I have a chance to review that. I don't think I can make a decision here today on how we're going to proceed. I agree that we want to hear this as expeditiously as possible, while also making sure we follow the right procedures for everyone and make the record as clean as possible for any potential further actions. Any concerns with that process? I'm not going to set a date. You all are going to work hard on getting this done as soon as possible, I think.
And Jody, I believe you still have access to all of those records, on top of which I know many of them were submitted to the court. So if you need anything, please let me know and I will send it to you. I don't want to inundate you with things I know you already have. Does that
It might be helpful if you submit to Jody what you think is relevant for each separate appeal. You know, maybe 4 emails saying, here's the documents we think is relevant to this one, to this one, to this one, to this one, and allow them to review that. Because I reviewed one Google Drive folder, it's quite voluminous, and so I think that'll help speed things up.
I agree.
Here's my question though. Are you wanting us to tailor it, what we currently have, or are you wanting us to submit what was previously submitted?
For now, just submit what you think is relevant, what you previously submitted. Just keep it there unless the city objects to that.
I'm sorry, was that a question for me?
Yes,
I'm sorry, listening to Ethan.
that's all right. The question was, the Fujas, do they just submit to the city everything that they previously submitted, or just what they wanted?
I'm happy if you want to tailor it. I'm happy to try to reduce the volume as much as we can. I do think the idea for each of the 4 appeals to have a separate email with the, so we know for each one, not just one group. So I appreciate the courts, you know, not the court, I'm sorry.
I'm not that high level.
I'm sorry. Your Honor, no, just, yeah, appreciate your approach on that.
Okay, so why don't you then, as quickly as able, Ms. Fuja, tailor it to whatever extent you believe is relevant in terms of briefing and documents and evidence. Submit 1 email for each of the 4 cases to the city and allow them, they will then compile it all plus what they have on their side and circulate that all to all the parties, and we'll see if that's the record, and I'll go from there.
Okay, but
Rob?
after I submit that, will I have an opportunity to object to what they submit after me?
Yes, you will certainly have a chance to file any objections you'd like to the record that the city provides.
Right.
Along those,
Mr. Patterson, can we make sure that each appeal is only the documentation that pertains to that appeal and not later information?
That's what I'm requesting. I think this might be a situation where we might have objections from both sides as to what gets submitted. I'll have to leave that to you all to address.
Okay. That's
my
fine.
my next question comes down to, do you also want me to tailor our appeal as I was instructed by the court at this time, or do you want us to leave the appeal as submitted?
For now, leave the appeal as submitted. I will decide once I review just the documents, what additional briefing and submissions I would request in terms of argument after that.
Okay.
And again, I will issue an order, and if you choose, you can object to that as well.
Okay.
It might be helpful if we have a lot of papers, which I expect we will, to have either a table of contents or Bates numbering, which I'm sure other than the attorneys here, people don't know what I mean, but that's where you give every page a discrete number that you submit so that you can refer to it by the Bates number. And I guess that comes from some case named Bates many years ago, but I don't.
I was always curious where that wording came from.
Yeah, but anyway, I'm just throwing that out. I don't know that I'm not saying we need to do that. I just think that might be a good idea to do that.
It would be. It's not something I think that the Fujas can handle. They don't have the documentation. Is that something you think you'd be able to handle once you have the?
Yeah, we can help the city to do that and make.
That'd be great.
Bates
Well,
number.
just to explain for your benefit, Ms. Fuja, a Bates numbering is just a numbering. It has usually like a prefix of appeal dated this day and then 00001, and it goes through all pages sequentially 1. So you can say, I'm objecting to the record found at pages 337 to 400, and we know exactly which documents we're referring to.
Yes, I understand what it is. I just don't know how I would add it.
Yep. I will leave that to the attorneys to handle.
This is going to take me several weeks. This is not my job. So this is going to take me some significant, several weeks to be able to go through and tailor these down.
And see,
Because not everything was remanded back, only specific issues.
This is the difficulty of having a court process while also trying to be sensitive to the humans involved in that process. I mean, I assume both sides are going to work as expeditiously as possible, and the city said they're going to, and they might need a couple of weeks to get any minutes or transcripts that might be needed. In the same vein, I would encourage you to do the same. In terms of, I mean, well, no, I don't have anything before me on that, so I can only make decisions on what I have before me and try to move this along as quickly as possible.
Also, when will a jurisdictional decision be made in accordance with 163B1A? So that, I mean,
You've raised some arguments regarding what I see as almost subject matter jurisdictional issues. However, that depends on the subject matter, which I don't know yet because I haven't reviewed any of the briefing or the documents. So with my intent, and this might change based on what I see, my intent would be when I say, here's how we're moving forward, I will also have a statement regarding my jurisdiction.
do you want me to present any written arguments on that or stick with what was presented orally today?
I have your email where you did raise that, and you have raised some oral comments and arguments regarding that. I do not wish, what I'll say is I do not want any additional briefing on that. I'll issue an order. If you want to object to it, you can. Beyond that, depending on what I decide, but I do have some documents and I have some arguments. I think I understand the nature of the argument. So I will not ask for any additional briefing on that from either side.
Thank you.
Anything else we need to cover? So we're getting the records out as soon as possible. Then I will issue an order regarding jurisdiction, potential consolidation, and potential briefing schedules.
One question I have for the city, and perhaps I know it's not pertinent to you, but we have made a request to the city for an understanding of what your fees are, because we're supposedly responsible for your fees relative to the fourth appeal. However, we have not received any documentation regarding what those fees are that you charge to the city. And so again, I would request of the city that we receive documentation of your agreement with the city regarding fees so that we know what we are committed to.
And I will, city's on the record here and part of this meeting, I'll let you all handle that appropriately. That is beyond me. With that, any additional issues?
Again, I would just ask that all communications that have been previously or will in the future be given from the city to yourself as hearing officer regarding this be forwarded on to us in their original format.
I think that's an appropriate request. Everyone, make sure to CC everyone else when emails are exchanged. We don't have a filing system, but that's the best we can do. Okay, well, with that, again, I encourage the parties to act as quickly as possible to get those records put together so we can, I'd like to resolve this as soon as possible. Thank you all for your time and participation. We'll have this meeting and I'll send out a brief little, essentially a minute entry for a court, a summary of what we've discussed today and the next steps. We'll get that out in the next little bit here. Thank you all.
Thank you.